The Speaker.
Honourable members, debate on the second reading of the following bill, which was adjourned earlier today, will be resumed. A bill entitled An Act to Provide for the Registration and Regulation of Real Estate Agents in order to promote transparency, accountability, and integrity in the real estate profession, to protect and assist persons engaged in transactions with real estate agents, and to assist in the detection and prevention of money laundering and terrorist financing and other related matters. Attorney General.
Thank you, Madam Speaker. Madam Speaker, may I inquire, is it 30 or 20 minutes for wrap-up?
It's 20 minutes for wrap-up.
20 minutes. In the Senate, it's 30. Much obliged. Madam Speaker, I thank you for this opportunity to wrap up what I consider to be an extremely important piece of legislation. Madam Speaker, I thank all honourable members for their contributions. I think that the contributions to this debate have been very constructive, and certainly as Attorney General, I welcome the submissions coming from my colleagues opposite. Certainly they are food for thought, and in some instances have found their way into submissions which I have asked to be circulated as I am now speaking by way of proposed amendments to this legislation. Permit me to dive directly in this process, therefore, to the answer that is required to some of the submissions coming from my colleagues. Madam Speaker, the Honourable Member for Mayaro, the Honourable Rushton Parry, made note of my submission that this legislation was driven to the heart of improving our fight against criminality and crime, and that this was, in effect, another money laundering, anti-money laundering, anti-fraud, anti-corruption passage of legislation which joins all of the others. The Honourable Member for Mayaro said that the other bills that were brought didn't meet with the level of success that he hoped he would have seen, and that he hoped that this one would in fact get there. I'd like to remind the Honourable Member, as he made the further submission relative to the FIU, and whether the work of the FIU was as robust as it ought to be in light of the number of suspicious transactions that have been noted in the period, by his reflection, 2014 to 2017. And if I could just say this, it must be a feature of absolute certainty that the criminal justice system is what was required to make legislation work. In answer to the Honourable Member for Mayaro, I will say it is a certified improvement that has been noticed. Don't ask the government whether that is true. Ask the Financial Action Task Force. The FATF gave Trinidad and Tobago such a confident recommendation to its plenary that we were removed from the list of jurisdictions that have strategic deficiencies in their money laundering and fighting of terrorism and anti-corruption regime. We, unlike most other countries, in fact, we were the only country graduating in that group. And quite astonishingly, the only criticism that came against the government of Trinidad and Tobago came from a past senator, a past minister of government of the UNC, in fact, Devant Maraj, on the FATF website when they were congratulating, when the president of the FATF congratulated Trinidad and Tobago and me, its Attorney General, for a marvelous job done by this country. The comment coming from my friend Devant Maraj was, Trinidad and Tobago has no money laundering convictions. Madam Speaker, that's entirely untrue. And in answer to Mayara's submission, the record will demonstrate that the criminal justice system has begun to work in a way that has never been seen before. The first couple of unexplained wealth orders are in court as we speak. We are looking at money laundering convictions as we speak. We're looking at people being indicted for serious, complex fraud and brought before the court in record time with plea bargaining legislation that this government brought. So for my learned friend to say that he had not noticed the working of the laws that we passed in this government's tenure, I just remind my friend, look to the near 1,000 orders that the Office of the Attorney General has received under the anti-terrorism legislation. Look to the landmark unexplained wealth orders that we have brought to court. Look to the pleas of guilt coming under the plea bargaining legislation. Look to the population of the sex offenders registry. And you will see a level of efficiency that you've not seen before because of other things we put in place. The criminal division bill, the family and children division bill, the criminal proceedings rules, the raising in the number of judges legislatively from 36 to 64, from 2 masters of the court to 25 as we move to full capacity, the opening of 165 courts. By the time we are finished in June of next year, Madam Speaker, I just tell my friend, hold on, have a look, and you will see the evidence there. Madam Speaker, permit me to say thank you to the members of the area, that is the Association of Real Estate Agents of Trinidad and Tobago, incorporated under Act number 10 of 2012. And permit me to also say thank you, a sincere thank you, to the newly formed Trinidad and Tobago Real Estates Association. And the TTREA, I can say that I met with them this week by way of a Zoom meeting. They represent over 200 persons in their package. And therefore, in answer to my friends' colleagues, we have had consultation with hundreds of persons via their representation coming from the Area Association and also the TTREA Association. And the correspondence, which I don't have time to go through, simply says, thank you for regulating an industry. Madam Speaker, in fact, it's quite amazing to me that no one prior saw it fit to regulate the real estate industry. All of us in Trinidad and Tobago know that land is the most important resource. And yet, Madam Speaker, with the registration system being as it is in Trinidad and Tobago for land, with the level of fraud declared at over $24 billion in the FIU reports for 1 year only, Madam Speaker, as we look to the cohort of this type of land fraud and the other types of fraud, it is staggering that no one has paid the attention to the regulation of the system by which we regulate land and also the system of the persons who sell, participate, or manage land. And therefore, Madam Speaker, I'm extremely pleased that this bill has received overwhelming support from the stakeholders themselves. Now, permit me, Madam Speaker, to jump to a few of the recommendations and observations coming. We at the Attorney General's office have, of course, been looking at the law over and over again. I take on board the recommendations coming from my friend in his very good presentation, the Honourable Member for Chaguanas East, made some very good observations about the level of training and requirements. But let me put this bill in simple form. Number one, the real estate agencies are going to be managed under this bill. First thing we do, we create a mandatory requirement for registration. All of the players involved in the land sphere who deal with land or property or in the real estate agency, there are 4 categories of them we've looked at. Number 1, you're a sales associate. Number 2, you're a broker. Number 3, you are a developer. And number 4, you are a brokerage. A sales associate is anybody involved in the business of real estate. You need only be registered at the Registrar General, meeting prescribed qualifications which are de minimis or little, and the anti-money laundering form that you have to fill out and the other formalities. The people who have to be licensed are the brokers and brokerages. They have to be licensed because they are going to be permitted the privilege of handling people's money. Right now, brokers act as stakeholders, hold on to monies that belong to other people, and unlike attorneys at law or other professionals, there are no standards in the industry to monitor them other than the common law. So the only person who's required to be licensed is going to be the broker or the brokerage. In the case of the developer, I thank the member for Tabakit for his observations and also the member for Mayaro. We are looking at what the law does not apply to. So there's a disapplication clause in the bill. The law does not apply to the state or state enterprises, HDC, etc., etc. But it also does not apply, and we are working on how this exception will be developed over time. It does not apply to somebody who acts for himself in his own land development as a developer. And therefore, Madam President, Madam Speaker, we propose an amendment to the definition of developer which would capture the categories that we're looking for. And now we're saying that a developer should be not tied to the Planning and Facilitation Development Act. A developer is a person who erects buildings or structures upon land for sale, causes infrastructure to be built or installed upon land for sale, or causes the subdivision of large parcels of land into smaller lots for sale. And what do we want from this developer? We want this developer to simply go to the registry, the Registrar General, fill out the form that says, I am a developer, I am acting under the provisions of this bill as an exception to the rule, log me as a developer, fill out my anti-money laundering form, etc., and take avail of the exemption under clause 5, 2D and E of the bill. This allows the real estate agents who deal with land, sales associates who need only be registered and not licensed, brokers who must be registered and licensed, brokerages which need to be registered and licensed, and developers who need only register themselves, all of them filling out the anti-money laundering form for the FIU. You need to be on the register so that the Financial Intelligence Unit can track your transactions. What does that give you? It gives you the certainty of the profession. You know who the person you're dealing with is. Number two, it gives you a remedy to go against these people in the event that they run afoul of the fraud that we have noticed. And I remember very well the example given to us by the member for Mayaro of the fraudster who was well known to the police in Trinidad and Tobago. But fraud is a reality, so you have a remedy against that. You also have a remedy against people who take your money, acting as brokers, spend it on something else, and then you have to go and sue them to collect the money. This law requires brokers and brokerages to have the money set aside in a separate bank account. It cannot be touched. It cannot be commingled with their monies, just like attorneys at law have to keep client accounts separate from their personal remuneration. So that's number two, the remedy aspect. Number three, it also manages to allow the Financial Intelligence Unit to look for the schemes of fraud. Because it's in the real estate business, as I've said time and time again, together with companies and cash, that you actually hide the proceeds of crime. So I'll remind Mayaro that in the operationalization of some of our works, the demonetization of our $100 bill was a radical, effective mechanism to uncover criminality. And we saw that in its many forms, be it tax evasion or fraud or other aspects, proceeds of crime. These have been discovered. And just to let the Honourable Member for Mayaro know, we are also working on a significant overhaul of the Financial Intelligence Unit. The Financial Intelligence Unit stands as an administrative unit at present. It is perhaps best modified into a hybrid unit. But Madam Speaker, where I'm confident is in watching the work of the Financial Investigation Branch. The Trinidad and Tobago Police Service operates alongside the FIU, and they have made rampant strides. In one instance, the head of the FIB was able to come to the population, having received a report from a member of the society that alleged that the Prime Minister was supposedly engaged in wire transfers and receiving money. Thanks to the Financial Investigation Branch of the Trinidad and Tobago Police Service, that lie was put to bed. That untruth, forgive me, was put to rest. And that, therefore, is a very good example of the police working in tandem. I want to remind, with the FIU, I want to remind it is this government, through the Commissioner of Police receiving the Anti-Corruption Investigation Bureau, which used to be at the Attorney General's office. The Commissioner of Police married that unit up with the fraud squad, with the other divisions of the Trinidad and Tobago Police Service, the white collar unit and the cybercrime unit, and put that unit into operation. And therefore, you are now seeing the purchasing power of legislation that is well thought out. The bill, Madam Speaker, also allows for the creation of a disciplinary committee, apart from the licensing committee. And the disciplinary committee and the licensing committee are both creatures. I thank the member for San Fernando East for an excellent contribution. They are underwritten by the appointments coming from the Judicial and Legal Services Commission. Why? We have modeled it after the other legislation that stands as precedent. You take the industrial relations construct at the industrial court, you take the tribunals that have been established, you look at the public procurement. We have put an independence of the Judicial and Legal Services Commission, appointing those people, and then we go the step further to say that no one shall have control over these entities. In other words, then, full autonomy and independence. We go further. We say that the alternates to these bodies shall be selected by the President of the Republic of Trinidad and Tobago, not the Cabinet, acting in her own discretion. So, Madam Speaker, this is actually quite novel legislation. It is robustly written. It can withstand all service requirements of proportionality and constitutional inspection. In creating the association and in answering my arrow, we did not intend to have area repealed. That's a matter for area incorporated by an act of a private act of Parliament to repeal itself. In fact, I've spoken to area about this. This body says this bill creates an association. The association is open to every single real estate player, broker, brokerage, or sales agent in Trinidad and Tobago, including the members of area. They will allow themselves to hold their first meeting. All of these persons, we've factored in the transitional provisions, will have the registrar of the Registrar General's Department act as the secretary for the purposes of the first meeting. It's contained in the schedule to the bill and in the clauses to the bill. Convene the meeting of all of the members, and the membership will elect who they wish onto the body, exactly like the law association does, engineers, whomever else. It is the body of the entity players that elects themselves into that. Therefore, there's no government control in the licensing committee, in the disciplinary committee, where the majority and the quasi-judicial functions are exercised by Judicial and Legal Service Commission appointees. Thirdly, you are not looking at government control in the association because the association elects its own people, president, vice president, treasurer, etc. So this allows that whole co-regulatory approach where the government receives the anti-money laundering forms, the Registrar General's intervention in issuing the registration or not, the Trinidad and Tobago Police Service has access, a court order has access to private information, because the register has a public part and a private part. The public part, the public can see, but only law enforcement, FIU, or court order permits access to the private register. That precedent has been set in the construct that we use for the creation of the non-profit organizations in the Non-Profit Organizations Act. Madam Speaker, what time is full time?
The time is 5:51:26.
Much obliged. I will pray that we do like the Senate and give the wrapping up to 30 minutes and not 12 by way of further consideration to 30 minutes. Madam Speaker, if I can say, we have also sought to amend the transitional provisions in the legislation. We are proposing a 12-month period of non-operation from proclamation of the law for sales associates and an 18-month period for the brokers and brokerages unless the period is extended. It may very well be, and it's an actual concern, that we will extend the time frame so that the capacity of the entities that have to approve their licenses by way of qualifications produced or assessed can be brought in. So if Reutech takes 2 years to do the course, we need to give 2 years time frame to manage it. If the methodologies recommended by Carney East quite commendably and intelligently are to find themselves into the prescriptions, those two can be factored as well, where you bring in the learnt aspect of being in the industry for as many years as you have been. Madam Speaker, this law, as it relates to the mandatory provisions of being a member of the association, etc., meet constitutional muster. That has been settled in the Nurse case at the Court of Appeal in Barbados and by way of express opinion coming from the AG's office. I believe that I am now at end of time. Madam Speaker, I will take the rest of it at committee stage and I beg to move.
Honourable members, the question is that a bill entitled An Act to Provide for the Registration and Regulation of Real Estate Agents in order to promote transparency, accountability, and integrity in the real estate profession, to protect and assist persons engaged in transactions with real estate agents, and to assist in the detection, and prevention of money laundering and terrorist financing and other related matters be now read a second time. All in favor say aye.
Aye.
Any against? The ayes have it.
Titled, An Act to Provide for the Registration and Regulation of Real Estate Agents in order to promote transparency, accountability, and integrity in the real estate profession, to protect and assist persons engaged in transactions with real estate agents, and to assist in the detection and prevention of money laundering and terrorist financing and other related matters.
Attorney General.
Madam Speaker, in accordance with Standing Order 68-1, I beg to move that the Real Estate Agents Bill 2020 be committed to the Committee of the Whole.
Honourable members, the question is that the Real Estate Agents Bill 2020 be committed to the Committee of the Whole. All in favour say aye. Any against? The ayes have it. This House will now go into the Committee of the Whole to consider the bill clause by clause. This bill has 83 clauses and 3 schedules. Members, could we have an agreement that where there are no amendments, the clauses to which there are no amendments, you will take those clauses as a block, so that we'll only take individually? All right, so thank you very much.
Clauses 1 to 2.
The question is that clauses 1 to 2 stand part of the bill. The question is that clauses 1 to 2 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 2 stand part of the bill.
Clause 3.
The question is that clause 3 stand part of the bill. Attorney General.
Thank you, Madam Speaker. I was just at a loss as to where my phone was for a moment, but I just saw it. Madam Speaker, we propose an amendment to Clause 3 specifically to treat with the definition of developer, coming out of the recommendations from Tabakit East. Sorry, I'm already anticipating a split of that constituency. Coming out of the recommendations from Tabakit and our own deliberations, and as echoed by Mayaro today, we felt it prudent to move away from the Planning and Facilitation Development Bill and to instead capture the definition in terms circulated. It allows us effectively to catch the widest form of personal development, whether it is by way of infrastructural lot development or just subdivision development or development of lots together with housing for sale and development. It allows us that full ambit in Clause 3 if we amend developer as per the circulated draft.
Member for Caroni Central.
Yes. Attorney General, you say you are disassociating the clause from the Planning and Facilitation of Development Bill totally, and including these amendments that you are suggesting here. There was another issue that came up in relation to that, having to do with whether someone is a full owner or part owner of a property. How is that going to be taken into account?
Because we've used developer means a person who erects, builds, or structures upon land for sale, causes infrastructure to be built or installed upon land for sale, or causes the subdivision or large parcels of land into smaller lots for land for sale. What we're doing is we're capturing all whole or part owners. If I point you to the fact that Clause 5 deals with Clause 5 2D, D accepts a person who deals with real property of which he is an owner or a part owner. So we're not registering that person. That's what I meant in the winding up when I said we're looking at certain other avenues that we need to capture. So we're not looking at that person yet. What we want to look at is E. The person is a developer. It's because the developer, as crafted in this definition, includes the whole and part owner, or even the person that causes the development in a consortium. So let's say somebody arrives with the property, establishes a limited liability company, vests the property into the company or pledges the property into the company, uses the capital from another person as a joint venture entrepreneurship there. Developer would capture all of that. Owner, part owner, individual, corporate entity, and then the management of how that goes. So I'm very comfortable with this definition of developer capturing that. What we want there is to strike a balance between the bona fide, genuine interest of people in developing their properties. And again, for the record, I declare my own interest. As you all know, I have significant development in my own personal life, as many members in this Parliament do. So for the record, I again say it. I said it in my piloting. And I want to, in fact, if I was one of those people, I want to catch myself. I want to make sure that I am not developing a property under a ownership position where I'm a developer or a single person myself. I'm not a real estate agent. I want someone like me to be compelled to go to the company's registry, fill out the form, put in the anti-money laundering, terrorist financing, proliferation financing information, submit all my personal information for law enforcement, FIU, and other people to have a look at so that it can be tracked properly.
Okay, could I follow this up by asking two questions? A company then is not captured here as a developer, but will fall under another law. Is that correct?
Sorry, Honourable Member. The company will be a company, an individual, a consortium, an arrangement. Any one of the multiple iterations will be caught as a developer.
But how does saying a developer means a person how does that capture all of this?
Sure. Person under the Interpretation Act includes an individual, a
All right.
company,
Or
etc. So
corporate
it's a
entity.
term of law.
Okay, and will there be any contradiction between this and what obtains under the 1962 HDC law?
That's as a registered developer?
Yes.
No. So there's no conflict, nor is there any implied repeal intended. The registering yourself as a trader in houses, coupled with the reliefs that Minister of Finance Imbert gave, that is intended to be that you access the developmental benefits of registering as a trader in houses. So that is a regime to cause a benefit to encourage development. What we want here is to have a unified registry where we capture all the players who engage in land, because the mischief that we're looking at is capturing the exploitation of the market, the conflict of interest in acting for both purchaser and as seller, dual agencies. We want to capture all of this, and I'll tell you, from a money laundering perspective as we relate to developer, that's where you're going to catch the largest potential for crime. The proceeds of crime poured into land where somebody has illicitly received it. And that person is now, quote unquote, wealthy enough to develop the land himself, using cash, developing some legitimate bills and some cash bills, as the stories go. That person as a developer will, for the first time in this country, be holding up a red flag by buying the registration. You have to register. All you're saying is, look, I am a developer and I am taking utilization of clause 5. It'll become section 5E. Section 5.2E, I am a developer, take notice to the whole world and come and check me if you wish. And that's all.
Okay, I'm comfortable with the explanations.
Sorry.
When you said a developer, right? The first part, the stem says a person shall not be regarded as engaged in real estate. I'll jump to 5. I'll wait until 5.
Okay.
I'll wait until 5.
All right. So, Member for Caroni Central, is it that you are withdrawing your amendment? Yes? Okay. So it's...
For the record, Madam Chair, I thank the members opposite, for joining us in this discussion on developer. It was Tabaki that raised the point first off, and certainly we were looking at it on our end as well. So I thank members for the joint thought.
Member for Tabaki?
Thank you, Madam Speaker. So just to clarify, there's no conflict between what is in the facilitation bill and what you have here as developer. There's no conflict.
No, because they're two different regimes. You mean the registration as a developer?
No.
Sorry,
the definition.
In the definition?
You see, with the 21 lots and simple development and so on.
No. So, if I may, because it's an important point. So the Planning and Facilitation Development Bill, that is intended to capture a definition of developer by way of large or small development for the purposes of whether you go to head office or decentralized office. So simple developments go to the regional offices, and complex developments go to the center aspect. So the aim and purpose of the Planning and Facilitation Bill is to say, which route do you go? Do you go to head office or do you go to regional office? And therefore, that definition applied there for complex and simple development. In this definition, we're looking to capture a different purpose. The purpose is people who are legitimately engaged in developing their own properties in whatever arrangement they do with someone else, and not acting as real estate agents, but they're developing 100 lots and they're marketing it themselves. Let them at least flag and register.
Yeah. I just want to be clear that there's no conflict.
So the amendment circulated by Member for Caroni Central is withdrawn. And the question is that Clause 3 be amended as circulated by the Attorney General. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that Clause 3, as amended, now stands part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clause 4.
The question is that Clause 4 stand part of the bill. The question is that Clause 4 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 4 now stands part of the bill.
Clause 5.
The question is that Clause 5 stand part of the bill. Attorney General.
Madam Chair, we were looking in Clause 5 to add an amendment to be sure that we caught the Auctioneers Act. So in Clause 5, where we deal with real estate business, we're saying that we've used the term auctions in 51A. A person engages in real estate business if he auctions or negotiates the sale, exchange, etc. Now, there's a rule of law which is debatable always, that a subsequent piece of law, if it's different from an earlier piece of law, and if it doesn't expressly amend it, it can be argued that it impliedly amends it. That goes either way. On one hand, it's thought that, look, nothing could except you from the obligation to be registered under the provisions of the Auctioneers Act, because surely that's a regime that stands on its own. But insofar as it could be argued that you are allowing in Section 5(1)A an auctioneer capability, we didn't want to run the risk. So out of an abundance of caution, we have sought to say in a new subclause 6 that nothing in the act shall affect the obligation of a real estate agent to comply with the Auctioneers Act. And that is just out of an abundance of caution.
Member for Caroni Central.
Yes, Attorney General, I want to raise two issues here. The first thing is the case of a person selling his own property. I want to suggest that we put in a clause which basically says, and you may adjust or reformulate as you think reasonable, a person seeking to sell his own property without aid of a real estate agent does not have to be registered as a real estate agent.
Sure.
Okay? Is it possible to include
Yes.
a clause like that? And the second thing that I want to suggest, unfortunately, it was missed in the document, is that a person engaged in the real estate business is so engaged on behalf of another person. That person is so engaged for compensation or valuable consideration. And the idea is to clarify this issue that a person may sell his own one piece of property, but the person who is a real estate agent is actually doing it on behalf of another person for compensation. If you'd accommodate that, that'd be great.
Sure. I thank the honourable member for his submissions, and I seek to address them as follows. The issue of allowing somebody the flexibility to do their own sale is paramount clear. We agree with that. We have captured it in Section 5(2)D. And here's what it says. So if you read the chapeau of Section 5(2), notwithstanding subsection 1, a person shall not be regarded as engaged in real estate business by reason only of the fact that, D, he deals with real property of which he is an owner or part owner. So that captures the essence of what the honourable member has circulated in his proposed
Which clause is that, AG?
It's at page 9 of the bill, at subclause 2D as in Delta. So,
No.
right. So what it says is, you are not regarded as being engaged in a real estate interest if you're dealing with property of which you are an owner or part owner. Now, let me explain why we use the word deal. We've dealt with deal because a real estate agent does more than just sell. They may lease, they may license, they may rent out on certain terms and conditions. So we didn't want to have the unfortunate position where you're legitimately managing your own property, you're not calling yourself a real estate agent, you're not acting for anybody on anybody's part, and you're treating with your own property. Your fundamental right to enjoy your property, which the Constitution clearly identifies in Section 4 of the Constitution, has to be preserved here. And therefore, we've kept that self-dealing, because it's much more than just selling your property. You may rent it, you may license it, etc. So somebody who's running a little guest house in Toko, who rents out the property and has some nice rooms, etc., a different law may catch them, whether they're dealing with themselves as econo-lodges and they're applying for benefits or whatever that might be. But they will not be considered to be a real estate agent here. Yeah? And then on the second point, which is dovetailed into your first point, where someone else is acting for and on behalf, whether for consideration which is valuable by way of cash or otherwise, right? That is caught in the definition of a real estate agent. When we look to Section 5.1, Clause 5.1, a person engages in real estate business if, and here we have the iterations A through E inclusive. You advertise, hold out, you auction, negotiate, sale, exchange, purchase, lease, engage in property management, you take part in procuring of vendors, purchasers, etc., directs or assists in the procuring of prospects, etc. So we've gone with the standard classic definition we've seen in a number of jurisdictions, British Columbia, New Zealand, the Cayman Islands, the Bahamas. We reflected on some of what Barbados is thinking of. So we've sought to capture that there, but the concern that the Honourable Member has just raised is in fact addressed in the bill. I can understand it takes a little while to catch up to this, and I know it's not because of an intelligence factor. It's fairly complicated, and it requires one to have an understanding of conveyancing and other management issues, which obviously all of us don't have.
So you are saying that all of this is captured in 5.1A to E?
5.1A to E, the latter part of your submission, and 5.2 subclause D on the first part of your submission, which you've circulated.
Okay.
Member for Caroni Central, are you now going to withdraw your proposed amendment?
Yes, I will. Yeah.
All right.
Thank you, Honourable Member.
So the amendments proposed by Caroni Central are now withdrawn, and I'll now put the question. The question is that Clause 5 be amended as circulated by the Attorney General. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is Clause 5 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clause 6.
The question is that Clause 6 stand part of the bill. Attorney General.
Madam Chair, consequent upon the amendments to Clause 3, where we amended the definition of developer, it was necessary to cause an amendment to Clause 6, because Clause 6 only contemplated in the version in the bill selling of individual lots. Clearly now, with the recasted definition of developer, we're going a little bit broader than that. As a result of that, Madam Speaker, Madam Chair, subparagraph A in the circulated amendments catches what the developer will be doing in the new reformulated version. So that's as circulated to capture the definition of developer. Then when we go down into subclause 2 of E, what we're asking for, we're causing this obligation of the developer not only to fill out the form that you're a developer at the registry, but also to fill out the completed AML CFT-PF questionnaire and the prescribed fee. And we're saying that that meaning is the same meaning as in Section 8, because Section 8 is where we had defined it originally. It's a concept which the Financial Action Task Force has asked us to include. We first introduced it as a parliament in the Non-Profit Act, which has now become law in Trinidad. Later on, you'll see an amendment, Madam Speaker, Madam Chair, where we are ensuring that that aspect of information is never made public. That is in the private registry. That's in the private part of the registry. It is only accessible to the Financial Intelligence Unit, to law enforcement, or under a court order. And then subparagraph B is just the consequential renumbering because of the introduction of the 1 as we have done, and therefore it bumps the numbering down. So that is, in summary, the rationale for the amendment to Clause 6.
Okay. The question is that Clause 6 be amended as circulated. Those in favor say aye. Those against say no. I think the ayes have it. The question is that Clause 6 as amended now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it.
Clauses 7 to 9.
The question is that clauses 7 to 9 stand part of the bill. The question is that clauses 7 to 9 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses 7 to 9 now stand part of the bill.
Clause 10.
The question is that Clause 10 stands part of the bill. Attorney General.
Madam Chair, Clause 10, we're proposing to make an adjustment. We had included an interesting phrase in 10C, C as in Charlie, and that is the reference to an attorney in fact. An attorney in fact is a power of attorney holder, as opposed to an attorney at law, who's obviously registered under the Legal Profession Act and called to the bar, etc. So this concept of an attorney in fact, when we dug a little bit deeper in the reflections, I confessed over the last couple of weeks, we felt it was not appropriate yet to have a foreign jurisdiction say that because you're not allowed to have a power of attorney, that you ought to be disallowed under this legislation. And we say that even though that's prudent, we've not yet amended our law to cause powers of attorneys to be limited that way. I can tell you, Madam Chair, that right now at the AG's office, I'm looking at amendments to powers of attorney, in particular perpetual powers of attorneys, etc., because the law is quite ancient. People have not been paying attention to it. We have some very clear amendments in mind, God willing, in the course of the next couple of weeks, but certainly in our return to government after the general election, we'll be able to manage that one.
Okay. All right, the question is that Clause 10 be amended as circulated. Those in favor say aye. Those against say no. I think the ayes have it. The question is that Clause 10 as amended now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it.
Clause 11.
The question is that Clause 11 stand part of the bill. The question is that Clause 11 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 11 now stands part of the bill.
Clause 12.
The question is that Clause 12 stand part of the bill. Member for Caroni Central.
Yes, Attorney General, I had raised this in my presentation, which is that in Clause 12, it talks about 21 days after his decision, that's to say the decision of the Registrar General.
Yeah.
And then it talks 21 days of the date of his decision in 2.
Mm-hmm.
But what it does not say in there is how long it will take to get a decision, yea or nay.
Sure.
And I thought that it is important, given the fact that part of the problem we have here is that you can make an application and it can take 2 years before somebody looks at it or responds to you, that we set a time limit for responding yea or nay. So I wanted to suggest, AG, that we have an item 12.4, which would read as follows: a decision to approve or deny approval shall be taken within 30 days of the submission of a completed application. I don't think it's something too onerous to ask, and I would be flexible on the number of days if you felt more days were necessary.
Madam Chair, I thank the Honourable Member for his submission. I understand exactly what the Honourable Member is driving at. To catch what we're actually doing, I mean, I understand the point. You want to make sure that there's certainty and a reasonable time frame attached
Yes.
to making a
Yes.
decision, which is spot on. But the understanding of Clause 12 has to flow from Clause 11. And unfortunately, it's like a flowchart formula. So Clause 12 applies. It's a fork. It's either you're saying yes and then you do certain things, or you say no and you do something. So Clause 12 is where the RG approves an application. Focus on application for a moment. He shall, within 21 days of saying yes, obviously, inform the applicant, enter the name, issue the certificate. Whap, you're done. 2, where the RG does not approve, you shall inform the applicant, give reasons in writing, 21 days. The application comes in Clause 11. So Clause 11, upon receipt of an application under Section 8, because that's where it springs from, the RG shall cause, here's the steps now, what I meant by flowchart. First step, notice to the world. Faris Al-Rawi is applying to be a real estate agent. That has to run in 2 newspapers, specify a date. You must do that within the time frame there. So upon cause notice, 2 newspapers, specify a date. The day shall be no less than the time frame in subclause 3. So the application comes in 11. When you put the application, it runs for no less than 10 days. After that 10th day, the period of objections is over. If there's no objection, you springboard to Clause 12. You fit into 12.1. In 12.1, you know, 21 days, inform, enter, issue. Go back to Clause 11 now. If during the period of objections you get an objection, then there's a different route that you follow. In the objection, you have to give it to the other person, tell them this objection has come in, they have an opportunity to address it, and then the registrar must do all of his things in subclause 5 of 11 within 21 days of receipt of the objection. If you have an objection and the registrar says no, you jump to clause 12.2, and that's where you inform the person there. So the timeline is mapped out by a combined understanding of clause 11 and clause 12 together. And it in fact follows a formula which we use in the trademarks division for periods of objection by way of notification, which is where you really get notifications, because the other older companies' request, for instance, if you're applying for a company name and it's valid for 25 days, there's no Faris has applied for X Company Limited and somebody has a period to object. So this formula has only now come in with non-profit organizations, with these kinds of things, etc. So I do understand and agree with the philosophy of my friend from Dr. Tiwari, but it's caught by way of the understanding of 11 and 12, which you have to really go through 2 or 3 times to catch.
But even with your explanation, AG, I think you will admit that there is no real certainty of time. Suppose there is no objection. There is no guarantee.
But there is a certainty, you see.
Huh?
So if I accept, there is a certainty in the amendment that you proposed, Honourable Member, through you, Madam Chair. A decision to approve or deny shall be taken, and I know the member says he's flexible in the language, etc., within 30 days of submission of a completed application. So that 30 days doesn't work because 11.1, immediately when you apply, you issue to say, hey, you've applied. The whole world knows. You know that they have a maximum of 10 days for objections to come in subclause 3, 11.3. Within 7 days of receipt of an objection, if any comes in, you have to give notice. The person may, for instance, say, well, I need more time to comply, I need an extra 10 days, etc. That may amplify the time frame in subclause 4. And then the RG shall, within 21 days of receipt of objection, here's where we put the certainty, decide on the merits. Obviously, from a reasonableness point of view, that could be flexible depending upon any request made in subclause 3. So this formula is designed in accordance with other laws that have worked. And the best example is in the trademark objection regime, where you're allowed, upon advertising for the issuance of trademarks, to come back and say you have an objection, and then a process follows. So this robust process of trademarking objections is what we used here because the RG's department is very familiar with the process, so there is certainty in the structure.
AG, with all due respect, I'm not convinced. I think this is a real problem in the bureaucracy of the public service. And I think the more we can insist on structures and systems to get efficiency and effectiveness, the better it is, rather than leave it to the whim or will of an individual. And I don't think this is a hard thing to concede. I mean, all of us would be better off for it.
Madam Chair, it's not
And
that
I'm flexible on the days, as I said. If you say 45 days, I'm fine.
All right, so I'll allow Attorney General to respond, and if there's no agreement, then I'll put it.
Sure. I want to assure my friend, my learned colleague, this is not that I don't want to take your objection, your position. I think it's reasonable. It's that accepting it in the way that it's put, or even in a slight version, will not make sense of the iterations of possibilities. That's the first point. Secondly, the member hit a very important point, which is the public service efficiency. I can tell you, Madam Chair, by the month of June, all things being equal, we will be doing all of this online with no physical documents. In fact, I have drafted already the amendment in law to cause that to happen. I gave notice in the miscellaneous provisions bills that we just did last week, saying that we were there, and that's because, Madam Speaker, Madam Chair, the AG's office has spent 5 years digitizing all of our records and building out brand new systems which are up and running. We're testing them right now. We've migrated all the data, both for the land registry and for the company's registry. So the certainty of time frame is going to go exponentially faster right now. So I understand the member's concern, but that was the old Trinidad and Tobago. That is not this government, Trinidad and Tobago. We're in a different stratosphere right now.
Okay, member for Caroni Central. So I'll put the question in terms of the amendment.
Yeah, I'll hold to the amendment.
Okay.
I'm sure they will vote against it, but that's okay.
All right, so honorable members, the question is that clause 12 be amended as circulated by the member for Caroni Central. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that clause 12 do stand part of this bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 12 now stands part of the bill.
Clause 13.
The question is that clause 13 stand part of the bill. Member for Caroni Central.
13.
13, you have an amendment.
Yes. AG, I think you would understand this because I think this was also raised by area. There is in this the issue of registration, in this bill, the issue of registration on the one hand and licensing on the other.
Yeah.
And what the question is whether registration, which requires you to do that periodically, licensing, which requires periodic renewal, and registration should be treated in the same way. So for instance, in certain professions, you simply register, you become a member, and that is updated. And I know in the legislation here later down, there is provision for the updating to the Registrar General of any changes. So I thought that registration and was a little redundant. That is not something I'm going to fight if you wish to retain it, but I think it makes sense to distinguish between registration and licensing. And in 4K, what I'm suggesting is that, 13 4K, what I'm suggesting is that this was also raised by area. The list of sales associates, I think, was left out.
Yeah,
And so I'm just asking for their inclusion.
sure, I appreciate it. May I, Madam Chair? So I understand why the honourable member would have made the suggestion for 3G, for the deletion of the words registration and if I could just explain why we put it in. Because registration can happen in a number of ways, initial registration, re-registration, or strike off on fresh application, we had to contemplate the iterations in the formula, because this formula has to apply to everyone. If you're a registrant, a re-registrant, or a struck off and fresh registration. So that's why we put registration and license. So we could capture that point, albeit that the licensing regime is only applicable to broker and brokerages. The licensing regime does not apply to sales associates, and let me explain why. We did not want to put people who did not want to ever touch other people's money, but who wanted to be real estate agents through the hassle of licensing. So that would be unfair to the single mother or single father or small entity who said, look, I don't want to go through this brokerage course. I don't want to have an escrow account. I don't want liability for nobody money. Now, that does not mean that sales associates have to work with brokers, because all that the broker does is hold client monies. So I want to say this to the population through you, because I know there are many people keenly listening to this. You don't need to give up part of your commission to a broker. You don't need to work with a broker. An attorney at law who has to do the transaction for you, they can hold the money. A bank who is acting as a stakeholder or a deposit holder, they can hold the money. The arrangement of stakeholding and escrow arrangements are separate. So I want to assure the small businessman, real estate person, you don't need to be registered as a broker because you're not handling client money, nor do you need to fall under the umbrella of a broker and share your slice of the cake with him or her. With respect to the list of sales associates, because all sales associates will mandatorily be caught by this legislation and have to register, because unless they're brokers, they're going to be sales associates, they're all going to be there. But we didn't want to freeze in time the transaction. I can tell you what is about to come in the registration of deeds and other aspects. We're going to capture the information of the sales associate on the deed by reference to the Board of Inland Revenue number. So I can tell you that I have drafted a unique identification bill where all of your information is harmonized in one number. Birth certificate, marriage certificate, your passport, your ID card, everything is one number, a unique identification number, and it includes residents and non-nationals as well. So we have that bill ready. I can tell you the Prime Minister and the Cabinet have approved already an arrangement with the government of Estonia, which is one of the leading countries in the world for e-commerce and structures. That is going on, but we have taken the steps to do this. Why? Because we have already digitized all of the information. Licensing, passports, births, deaths, marriages, deeds. We've spent 5 years digitizing Trinidad. So inclusion of a list of sales associates would not capture the best purpose, because those sales associates may go from transaction to transaction elsewhere or may be registered under other agencies as well. So I'd respectfully decline the invitation, but catch the concept and tell you that they are registered as sales associates by the mere fact of being in the industry.
Okay.
Okay, so
I have no response to that.
are you still standing by your amendments?
No.
Or you withdraw them?
I mean, I take the if the AG insists of the connection between registration and licensing, then understand the simple explanation of the list of sales associates, but if he sticks with the registration and licensing, I said that I would not fight that, and therefore I will also withdraw 17, 1 and 2, the deletion of that which relates to that.
Okay, so if I understand you well, Member for Caroni Central, you're withdrawing your proposed amendments for clause 13, and you're giving me notice that you are also going to withdraw the proposed...
17.
Okay, thank you very
17,
much.
because they are connected, they are
Okay.
related.
Thank you very much. So the question is that clause 13 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 13 now stands part of the bill.
Clause 14.
The question is that clause 14 stand part of the bill. Attorney General.
Madam Chair, out of the need to ensure that the private register keeps specific things private, we must amend clause 14 by specifically stating that the AML CFT PF risk assessment questionnaire should never be made public. That is for private purposes for the FIU. And other entities, law enforcement, etc. So that is the rationale for the amendment to clause 14, to keep it strictly private.
Okay. The question is that clause 14 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 14 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clause 15.
The question is that clause 15 stand part of the bill. Attorney General.
Chair, we propose the same rationale for the secrecy of the AML CFT questionnaire. It's the same rationale for clause 15 to make sure that that stays strictly private as a private aspect of the register, not the public aspect.
The question is that clause 15 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 15 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clause 16.
The question is that clause 16 stand part of the bill. Attorney General.
Madam Chair, clause 16 is where you have the custody and access to the register. It was important for us to tidy that up a bit, to say that the RG would only give certified copies for the public register. So in subclause 3, for instance, you're looking at the words public to be inserted in that clause, because as it reads right now, you could pay and get both the private and public, which is not the intention. It should be just the public. The supervisory authority, etc., has the access under subclause 4, so we've taken care of that. In subclause 5, we're saying after the word license, we're also putting in the words or is an AML CFT PF assessment questionnaire. This keeps it in conformity with what we did previously, which is to maintain the secrecy and confidentiality of that questionnaire so that the public is protected by only having the supervisory authorities have access to that and not the general public.
Thank you. The question is that clause 16 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 16 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clauses 17 to 19.
The question is that clauses 17 to 19 stand part of the bill. The question is that clauses 17 to 19 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 17 to 19 now stand part of the bill.
Clause 20.
The question is that clause 20 stand part of the bill. Attorney General.
Madam Chair, we are proposing that we improve clause 20. Clause 20 is surrender, cancellation, and registration. And here's where the RG shall cancel the certificate in certain circumstances. If you surrendered it, if you died. What was missing from that is where the committee has revoked and therefore instructed the registrar that the committee has taken a decision to revoke. Obviously, the registrar has to do something upon that. So here's to allow the power for the RG to do that. And obviously, if you no longer meet the muster or qualification under Clause 10, then a similar effect has to happen. So it is to broaden the circumstances of the RG acting to give her or him the legislative springboard to do that.
The question is that Clause 20 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that Clause 20 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clause 21.
The question is that Clause 21 stand part of the bill. The question is that Clause 21 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 21 now stands part of the bill.
Clause 22.
The question is that Clause 22 stand part of the bill. Attorney General.
Madam Chair, coming out of our consultations with AREA and with the TTREA, there was a recommendation that we add a broker into this board. So here's where we're doing the Real Estate Agents Association, and the members of the board shall comprise. And what we want to do is to ensure that we have a broker as part of that association, in addition to the other members described in the legislation being finance and real estate. So we're inserting the word who is a broker into the first part of 22A Roman 1. And then we're deleting the word and then we're going to add into 28.2 Roman A2, we're going to insert a new clause, one member who has at least 5 years experience in real estate business. So what you're going to have effectively under subparagraph A is 3 Roman numerals, 1, 2, and 3. 1 will be a member who has at least 5 years experience in real estate and is a broker. 2 will be a member who has at least 5 years experience in the real estate business. And 3 will be a member who has at least 5 years experience in finance. And that therefore makes sense. The stakeholders said, look, you need to at least have a broker mandatorily in that as a skill set, and we agreed with them.
Okay. All right, so that the question is that Clause 22 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that Clause 22 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clauses 23 to 31.
The question is that clauses 23 to 31 stand part of the bill. The question is that clauses 23 to 31 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 23 to 31 now stand part of the bill.
Clause 32.
The question is that clause 32 stand part of the bill. Attorney General.
Madam Chair, we needed to insert the capacity of the committee to revoke, because a revoke is beyond issue, renewal, or cancel, because you may have a revocation which is not a cancellation. So it is simply to add in the word revocation, both into subparagraphs 1A and 1B. That's 32, 1A and 1B.
The question is that clause 32 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 32 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clauses 33 and 30 to 39.
The question is that clauses 33 to 39 stand part of the bill. The question is that clauses 33 to 39 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 33 to 39 now stand part of the bill.
Clause 40.
Question is that clause 40 stand part of the bill. Attorney General.
Madam Chair, in 40, subclause 4, we're saying that we should delete the word each and substitute the word one. So where an application for a license is being made on behalf of a company or partnership, that application must be signed by 2 directors or 2 partners, as the case may be, each of whom must be the holder of a valid license, What we're saying is one of whom. So if we take off each, we would instead have one. And the point was made to us by TTREA that many of the small entities don't have two people. It's just a one-man show with associates. And that was, of course, a very powerful submission. So I thank the TTREA for making that submission to us. I understand that the Honourable Member, Dr. Tiwari, probably has a submission.
Central, I believe you have a proposed amendment with respect to clause 40. Or is it a new clause you are proposing?
Yes, in clause 40, I'm proposing a similar amendment about time for this one.
Oh, so you're proposing a new subclause?
Yes.
We include it?
Yes. You wanted me to speak to the Attorney General's?
Sure.
Oh, sorry, I'm sorry.
No, I understand him.
Okay,
I
so I
think I'm
want
pretty
to
clear.
speak to your proposed amendment.
Yeah, I have a proposed amendment.
Yes.
Are you ready for that or no?
Yes, that's
Yeah.
it.
What I'm proposing here is the process of licensing shall be executed by the authority within 30 days of an application being received. Again, it is the same principle. You have a process, there is a time limit, you get the job done, yea or nay.
I understand the Honourable Member's submission. We've sought to capture the process with certainty. I want to say with flexible certainty, because there are different formulae that apply in clauses 41 and 42, which effectively replicate the provision for licensing. In clause 41, we allow for the application to be made, the process of objection, the certainty of timeframes for giving notice that the objection has been given, i.e. the fair party treatment, the fair hearing treatment, and then the process of, obviously advertising comes before that, the response mechanism within 21 days, and then you must make a decision. In 42, we bifurcate the response. If you agree, then there's the certainty of time frame there, and if you don't agree, then there's also the certainty of time frame there. Both with respect to licensing and registration. Of course, if you get an objection or you're aggrieved by any aspect, you have the right to go to the court. So whilst I understand the formula, the new clause 40 proposed by the Honourable Member is captured in the working mechanisms of clauses 41 and 42 of the bill as structured.
Central?
Now, again, I would say that while there is a process here that is outlined, there is no definitiveness, there is no certainty that a matter will be dealt with in so many days or such and such amount of time, but only in relation to the processes identified. And because of that, I feel I must hold it. I have a feeling that some of these things are going to, specifically this issue, for both issues that I raise, are going to come back to haunt us.
General, I believe you have some other amendments to clause 40.
Yes, Madam Chair. So I dealt with 44.
Yes.
In 5B, 5C, 5, right. What we're doing there in 40, in the other subsections, we are deleting the words two directors who are brokers and substituting one who is a broker. And in 5C, Roman 2, two partners who are brokers and substituting one partner who is a broker for the same rationale made to us by the TTREA that you may have a brokerage with just one person in it, a broker with one person and associates working, and that therefore they just simply didn't qualify because they'd have to go out and find somebody else who's a broker, and they just wanted to be a one-man show. So those are the reasons for the amendments to clause 40 as circulated.
Okay. So I'll first put the amendments proposed by Member for Caroni Central.
Sorry. I understood the member's question to be relevant to clause 41, but in any event to be a new clause, which technically comes at the end of our fulminations. I didn't think that the member, now that I've heard what the Honourable Member has said, was causing an amendment to clause 40, in which case there's only one amendment before you, which is the one which I have circulated.
Well, maybe the member, I should allow
Sure.
the member an opportunity to clarify. I
Yes,
really
please.
took it that it was a subclause that
Okay.
he was asking to be added.
Yes, it's a subclause under 40. I think what happened in the typing, that it was
Oh, I see.
It
left
was
out.
I
Took it to be a
apologize.
subclause to clause
Yeah.
40. Yes?
Yeah,
Apologies.
So,
okay, it's-
just for clarification, I will put the amendment as proposed by the member for Caroni Central,
Sure.
and then
Yes,
the
ma'am.
ones proposed by the Attorney General. So the question is that clause 40 be amended as circulated by the member for Caroni Central. Those in favor say aye. Those against say no. I think the noes have it. The question is that clause 40 be amended as circulated by the Attorney General. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 40, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clauses 41 to 53.
The question is that clauses 41 to 53 stand part of the bill. The question is that clauses 41 to 53 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 41 to 53 now stand part of the bill.
Clause 54.
The question is that clause 54 stand part of the bill. The Attorney General.
Madam Chair, we're proposing again, because of submissions coming to us from AREA this time, the Association for Real Estate, that one incorporated by Act of Parliament. AREA made the recommendation to us that the disciplinary committee should have the benefit of a broker being on that entity, the DC, the disciplinary committee itself. In those circumstances, we thank them for the recommendation and propose that we modify the composition, the de minimis composition of members, to include a person who has at least 5 years brokerage, one broker with at least 5 years experience, by inserting a new subclause D. So that'll be 54(1) new D, in term circulated.
Okay. The question is that clause 51 be amended as the question is that clause 54 be amended as circulated. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. The question is that clause 51 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clauses 55 to 82.
The question is that clauses 55 to 82 stand part of the bill. The question is that clauses 55 to 82 now stand part of the bill. Member for Caroni Central.
This is not an amendment. I just want to ask the AG. I have no more amendments. I just want to ask the AG a question. All these issues relating to disciplinary considerations and so on, and we have the mentioning in the bill, of course, of a code of conduct. We have those things with the bill?
So we don't have the code of conduct yet, and that's because we want to draft it in coordination with the real estate agents. We have a draft ourselves, but I had not had the opportunity to circulate that amongst their membership. And really and truly, we wanted to have the stakeholders themselves agree, because the versions of code of conduct that we found come from other jurisdictions and don't marry our real experience. So we wanted to bring them on the table. In fact, with the formation of the TTREA, we now have over 200 members represented, and they formed themselves very commendably on account of this bill coming to the front. They took the initiative, and I compliment them for that, just like AREA has. So we will settle the code of conduct in conjunction with the practitioners, and we intend to do that with immediacy.
Okay.
Okay?
So the question is that clauses 55 to 82 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 55 to 82 stand part of the bill.
Clause 83.
The question is that clause 83 stand part of the bill. Attorney General.
Madam Chair, we're proposing, again, thanks to the consultation that we've had with the industry, that we put the transitional provisions in a more careful way. We are recommending that there's a 12-month period for people who are sales associates to bring themselves onto the register. But we're saying that that 12-month period can be adjusted by way of order. In other words, then the time can be extended. It could never be retracted or made smaller, because we'd be taking a legitimate expectation problem onto our hands, and we would obviously not do that. So we'd be lengthening the period, if anything at all. Secondly, what we're doing with respect to a broker is we're giving them 18 months for the period of coming into force of the Act. I think we're missing some words here. Yes, ma'am, we are in subclause 2. A person who engaged in the business of a broker immediately before they come into force may continue to engage in the business, A and B, for a period of 18 months from the commencement of this Act, before the full stop. Madam Chair, if you could put in the same words at 83(1), or such longer period as the minister may by order determine. I apologize. And again, that is with a view to extension. Now, Madam Chair, I'm aware, and we want to go to the agencies that offer these courses for the certification. And I actually want to take on board some of what Honourable Member for Caroni East has said about learned qualifications, etc. I think that there was a very interesting submission coming from the member. So we will be giving the flexibility to, once we check the capacity for qualification, because remember, these brokers have to have qualifications. What those qualifications are and the capacity, that period of 18 months is likely to be amended. Okay, so that's the rationale for the new 83, moving what we have there and putting this other one.
Member for Caroni Central.
No, I'm fine, Madam Speaker.
You okay? All right. Okay, so the question is that clause 83 be amended as circulated and further amended to delete in subclause 2 the full stop after Act, and to include the words or such longer period as the minister may, comma, by order, comma, determine, full stop. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 83, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clauses Schedule 1.
The question is that Schedule 1 stand part of the bill. Attorney General.
Madam Chair, we had a recommendation coming from the industry that they felt that the quorum of 7 was a little too high, and therefore we've sought to adjust the quorum to 5 instead of 7. And that is in Schedule Part A, which treats with the constitution of the association. If we go down to quorum of the board 14, which is on page 43, I apologize, it should be circulated as me reading in paragraph 14, right? Yeah? So, sorry, it was on the other side. I apologize. I wasn't looking. So it's at page 14, so it's at paragraph 14, and then we substitute 7 with 5.
The question is that Schedule 1 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that Schedule 1, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Schedule 1, as amended, now stands part of the bill.
Schedules 2 and 3.
The question is that Schedules 2 and 3 stand part of the bill. The question is that Schedules 2 and 3 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Schedules 2 and 3 now stand part of the bill. Honorable members, the question is that the bill as amended be now reported to the House. Those in favor say aye. Aye. Those against say no. I think the ayes have it. This committee meeting is now adjourned. The House will resume. Attorney General.
Thank you, Madam Speaker. Thank you, Madam Speaker. Madam Speaker, I wish to report that the Real Estate Agents Bill 2020 was considered in Committee of the Whole and approved with amendments. I now beg to move that the House agree with this report from the committee.
Honorable members, the question is that this House agree with the committee's report on the Real Estate Agents Bill 2020. All in favor say aye. Aye. Any against? The ayes have it. Attorney General.
Madam Speaker, I beg to move that a bill entitled An Act to Provide for the Registration and Regulation of Real Estate Agents in order to promote transparency, accountability, and integrity in the real estate profession, to protect and assist persons engaged in transactions with real estates, and to assist in the detection and prevention of money laundering and terrorist financing and other related matters be forthwith read a third time and passed.
Honorable members, the question is a bill entitled An Act to Provide for the Registration and Regulation of Real Estate Agents in order to promote transparency, accountability, and integrity in the real estate profession, to protect and assist persons engaged in transactions with real estate agents, and to assist in the detection and prevention of money laundering and terrorist financing and other related matters be forthwith read a third time and passed. All in favor say aye. Aye. Any against? I think the ayes have it.
A bill entitled An Act to Provide for the Registration and Regulation of Real Estate Agents in order to promote transparency, accountability, and integrity in the real estate profession, to protect and assist persons engaged in transactions with real estate agents, and to assist in the detection and prevention of money laundering and terrorist financing and other related matters.
Leader of the House.
Sorry, ma'am. Madam Speaker, possible for us to do the Senate amendments to the electronic monitoring, please?
Thank you, Madam Chair. I do this on behalf of my colleague, the Minister of National Security, only because I wrapped up the bill in the Senate as we went ahead. Madam Chair, Madam Speaker, I beg to move the following motion standing in my name. Be it resolved that the Senate amendments to the Administration of Justice Electronic Monitoring Amendment Bill 2020, listed in the appendix, be now considered.
Generals, the question is that the Senate amendments to the Administration of Justice Electronic Monitoring Amendment Bill 2020, listed in the appendix, be now considered. All in favor say aye. Any against? The ayes have it. May I ask, in terms of proceeding, if there's been discussion with the acting whip? Okay, so do we take these individually or do we take them en bloc? Okay, so class, we'll take them all as one. As the court, please.
Clause 4, delete subparagraph A, Roman numeral 3, and substitute the following. By deleting the definition of court and substituting the following definition. Court means a judge, master, district court judge, magistrate, registrar, senior magistracy registrar, and clerk of the court, magistracy register, and clerk of the court or coroner as applicable. Clause 7. In the proposed section 8.1, insert after the word function the words or as required by law. Clause 10. In paragraph B, in the proposed subsection 2, delete the words and where necessary, the person shall be committed to appropriate custody while awaiting the report. Clause 14. In subparagraph A, in the proposed subsection 1A, delete the words is negligent and substitute the words willfully or recklessly. Clause 16. In paragraph B, in the proposed subsection 2A, delete the words the court in writing and substitute the words in writing, the court and any other person affected by or having an interest in the change in circumstances. Clause 25. In the proposed fourth schedule, delete the words director/manager, electronic monitoring unit, and substitute the words justice of the peace.
Attorney General.
Thank you, Madam Speaker, and I thank my colleagues for indulging us at this hour. I'll be very quick. In the Senate, Madam Speaker, we had cause to have reflection on this bill, and we received amendments coming in the Senate, which we are now bringing before the House. Targeting those, let's go immediately to Clause 4. We're proposing an amendment to the definition of court simply because, through inadvertence, we had omitted one of the creatures of law, being the senior magistracy registrar and clerk of the court. So we're simply just adding that person in so that we can capture the amendments that we took into by the criminal division creation of those categories. With respect to Clause 7, in Clause 7, we are proposing an amendment to Section 8 of the Act. That section is the confidentiality of information. And what we're saying is that every employee should keep secret this material, and that it is so in the course of his exercise or in the function of his positions, he's bound to keep it secret, save that he is required by law also to do that. So we want to make sure that it's not only by virtue of your function, but if there's a requirement of law, that we add in that obligation as well. Just keeping it to the core, trying to catch all of the measures by which this obligation is to be bound and managed as well. In Clause 10, we are proposing, Madam Speaker, that we adjust Section 11 of the Act. And in Section 11, we were including for the first time that before making a decision under subsection 1, a report shall be requested from the director concerning the person, which the director shall cause to be provided as soon as practicable, etc. This was specifically in the context of the exercise of mercy, the power of mercy, etc., pardon. Because this concept of pardon could be that you are seeking a pardon whilst you are not in custody. In other words, then, you may have already served your sentence, you're out, but you just don't want the conviction on your record. In those circumstances, you are not necessarily in custody. So including the words, the person shall be committed to appropriate custody while awaiting the report, did not make sense because somebody may be outside in liberty, and he didn't want to have an argument that that person who has already served a sentence, etc., and who still has a conviction on his record and who wants a pardon should be readmitted into custody. So we're removing that language, even though it came from Section 12, subclause 2 of the existing Act. The next one that we look at, Madam Speaker, is in the context of Clause 14. We're seeking to add the words willfully or recklessly. Clause 14 treats with the insertions of negligence. We're putting a civil obligation that people who receive the electronic monitoring unit should be liable in negligence if they damage the unit. But negligence was respectfully too low a threshold, and therefore we have sought to qualify the mental intention by including the words willfully or recklessly, so that a much higher standard is observed in this particular progress, so that people aren't just, lightly brought into the liability of the cost of the device, etc. The next one that we look at is Clause 16, where we propose that that we delete the words "the court in writing" and substitute the words "in writing the court and any other person affected by or having an interest in the change of circumstance." So Clause 16 treats with an amendment to Section 19 of the Act. And here is where we put in the obligation in a new subsection that if there was a change in circumstance in the person who is being monitored, that you should not only tell the court, but everybody else who has an interest in the change in circumstance. So somebody is wearing an electronic monitoring unit, the house burned down, something happened to them, they had to move. The virtual complainant, who is in a domestic violence setting, for example, or the Children's Authority, or anybody else in that structured arrangement, should also be given actual notice of the change in circumstance, and therefore that is the reason for that particular amendment. The last one we do is in Clause 25. In Clause 25, we had a recommendation coming that the affirmation or the taking of the oath should be done in the presence of a justice of the peace. We agreed with that submission, even though the Oaths Act says that you take an oath before somebody who has the authority to take an oath or by consent. So if I consent to take an oath with the member of Sawa Barataria, then he can lawfully take that oath. That's in the Oaths Act. But insofar as this oath was of a slightly larger importance, we thought it prudent to accept the recommendation to take that oath before a justice of the peace. Those are the reasons for the proposed amendments, and I beg to move.
Honorable members, the question is that this House agree with the Senate in the amendments to the clauses 4, 7, 10, 14, 16, 25 of the Administration of Justice Electronic Monitoring Amendment Bill 2020. Attorney General. Honorable members, the question is that this House agree with the Senate to the amendments to the clauses 4, 7, 10, 14, 16, 25 of the Administration of Justice Electronic Monitoring Amendment Bill 2020. All in favor say aye. Any against? The ayes have it. Leader of the House.
Thank you very kindly, Madam Speaker, and thank you to my colleagues for that indulgence. Madam Speaker, I beg to move that this House do now adjourn to Friday, the 15th day of May, 2020, at 1:30 p.m. Madam Speaker, on that day, we will continue debate on the motion of the Joint Select Committee appointed to consider and report on the Gambling, Gaming and Betting Control Bill 2016.
Honorable members, the question is that this House do now adjourn to Friday, the 15th of May, 2020, at 1:30 p.m. All in favor say aye. Aye. Any against? I think the ayes have it. This House now stands adjourned to Friday, the 15th of May, 2020, at 1:30 p.m.